Yes, Mr. Barnes.
Please, my lords, I appear on behalf of the appellant claimant in this case, leading my learned friend Mr. Stockwell. The respondent defendant is represented by my learned friend Mr. Davis, King's Counsel. This is an appeal against the decision of Master McCloud made on the 22nd of June 2023, following an earlier hearing on the 29th of March.
Yes.
She granted permission to appeal and heard outline submissions at that stage in relation to leapfrogging this matter to yourselves. And in September, my Lord Justice Coulson directed that the transfer be accepted.
Yeah. Well, just before we go on, can I just indicate that obviously we've read the papers, which happily are not too voluminous, and we have what we think is a keen appreciation of the issues between you.
I'm grateful, my Lord. There is one preliminary matter, my Lord, relating to an application made with the notice of appeal, specifically an application for permission to rely upon several witness statements.
Yes.
From the claimant solicitor.
Can I just indicate, obviously we've discussed that between ourselves, can I just indicate what may be the most efficient way of dealing with that? We've obviously read the statements, and therefore what we would suggest is that the parties deal with the appeal on the basis that we've read the statements. If we have to make a formal ruling as to their admissibility, as it were, then we would. But because we've read them, we think that it's best for the appeal to proceed on the basis that those statements can be referred to. We're not confident that they make a huge amount of difference to the issues that we have to decide. But that's a separate point.
I'm grateful, my Lord. What I would propose doing, my Lord, is this. Firstly, addressing the background to the case in fairly short terms and rehabilitation generally. Secondly, making three general observations, which we say are of overarching relevance to the appeal today. And then thirdly and finally, turning to the specific grounds of the appeal before you. In relation, my lords, to the background, you'll have seen the claim is one for damages for catastrophic injuries following a road traffic accident on the 8th of June 2020, with the claimant suffering a very severe traumatic brain injury. He was initially treated in hospital and then subsequently in a number of residential rehabilitation units before finally discharging into the community, into a property of his own in August 2022, a little over 2 years post-accident. I can inform the court that notwithstanding this appeal, the parties have progressed the claim and provisionally agreed a settlement. We are awaiting court approval of that settlement. It's one of a lump sum of 5.6 million and periodical payments of £170,000 a year.
That's the sorry to interrupt. That's the continuing cost of care, or the continuing cost of care and loss of earnings.
That's care and case management, my lord.
Right. Okay.
For the rest
How
of the
many
payments,
hours is he getting in terms of care at the moment?
Currently, my lord, he has 24-hour care. Yeah. He has a single carer, 24 hours a day.
Single carer, 24 hours a day. Thank you.
Yes.
Sorry to interrupt.
No, and for your lordship's information, the care is sleeping overnight. The capitalised valuation of the settlement is one of between 14 and 14.5 million pounds, perhaps giving an indication of the severity of the injuries that were suffered. I should also alert your lordship to this one procedural wriggle which is ongoing. There was an application made last year by the claimant's mother, Kate Shepherd, to replace the litigation friend. That is part of a very long and acrimonious history in this case. It came before Master McCloud in October, and she refused or rejected the application. an appeal is outstanding in relation to that. I understand and I'm told that it has been placed before a High Court judge who has raised a query as to precisely who the respondent to that might be. It having been suggested in the notice of appeal that the respondent is the defendant, whereas actually it's the current litigation friend.
And you said that there had been a provisionally agreed settlement. You said that that was awaiting court approval.
It is, my lord. It was provisionally to have been listed before Master McCloud. Her recent resignation may alter that. I understand that those instructing me and my learned friend have written to the court seeking a listing either before another master or before a High Court judge.
Right. And is that affected by, that's to say the approval process, is that affected by the outstanding appeal by the mother?
No, I don't believe it is, my lord, because currently the claimant's former partner, Laura McGarry, remains a litigation friend.
Yeah.
She has given instructions to agree the settlement, and unless and until she is replaced, we say that we have sufficient authority to progress to an approval. The point before your lordships today is a relatively short one, and it relates to the recovery of the costs incurred by the claimant solicitors in attending meetings in relation to the claimant's rehabilitation. As your lordships...
I'm sorry to quibble. I'm not sure that's quite the right way of putting it, is it? Because this is a dispute that arose on cost budgeting.
Yes, it is.
So it's not costs incurred.
Well, that's an interesting point, my lord. The budgeting...
That's why I raised it. The costs incurred are a different beast as far as cost budgeting is concerned. And I've been worrying away at this over the last few days, but it seemed to be clear that what the master was doing was referring to the future. And at one point she says future and underlines it, the future costs. Well, not the costs incurred.
Well, she was, my lord. The difficulty with it is that she sought to identify and determine a point of principle that would apply equally, we say, to the incurred costs. Because if, as a matter of principle, a claimant solicitor cannot recover the costs of attending case management meetings, then that would bite equally heavily at detailed assessment on those costs already incurred. And you may have seen, my lords, from some of the discussion before Master McCloud in the transcript, one of the points that arose was whether or not the previous attendance by the defendant solicitor at the case management meeting was such as to throw doubt on the submissions that were being made. And Master McCloud noted that had that been an issue raised, or were that to be an issue raised at detailed assessment, it may well be that it would be caught by the same ruling of principle which he proposed to make. And I suppose the point that we make is that the court cannot today look at the future estimated costs in isolation, this being a point of principle. If the master had looked at the specific work and deemed that it wasn't reasonable, appropriate and proportionate, then I recognise that that would have been limited to those estimated costs. But once she identified and decided to determine the point of principle, we say that goes to costs much more widely.
The difficulty is that she almost certainly wouldn't have had the power to make a ruling about costs incurred.
No, she wouldn't.
On a cost budgeting hearing. So we have to be a bit careful, don't we, about then saying, well, the appeal encompasses matters that the master couldn't have decided.
Well, I agree, my lord, but the reality is that notwithstanding that difficulty that she undoubtedly had, And we agree, of course, that she didn't have the power to interfere with the incurred costs at that stage. Notwithstanding that, she did propose to determine the point of principle and then to push the matter up to yourselves essentially for a definitive ruling one way or the other. And it seems to us, although we're very much in the court's hands, but it seems to us that if the court today determines that point of principle, then it is inevitably going to impact upon the assessment of costs, whether at detailed assessment or on cost budgeting. Now,
Right, well, I understand that.
It's a point
That submission.
It's a point that's occurred to us, my lord, because one of the submissions I'm going to make is that when one looks at the history of this case, there were clearly costs incurred attending a case management meeting, which we say are conceded essentially as reasonable by the defendant, by the respondent. Now, those are necessarily costs incurred rather than estimated costs. But we say the appeal, having opened up this point of principle as it has, we should be entitled to look at the matter in the round or be prejudiced potentially by any ruling.
Yeah, okay, well, that's that point. I understand that submission. Thank you.
Can I deal fairly briefly, my lord, if I may, please, with rehabilitation in the wider context of personal injury and clinical negligence claims? We say that the approach of relevant parties, involved parties, and the courts reflects a wider focus in the medical world as to the benefits of rehabilitation in fostering recovery. It is supported and recommended by the relevant NICE guidelines, which are in our skeleton. I needn't refer you to them. It is encouraged by the relevant pre-action protocols, both the personal injury and the clinical negligence protocol, and it is endorsed and encouraged by the Rehabilitation Code, which is a non-statutory code agreed by numerous bodies right across the industry. Both
Who actually publishes the Rehabilitation Code? I know it's approved by Apple and all the major players, but I just wondered who actually published it.
I don't know the answer to that, my lord. I'm embarrassed to say.
Well, that's right. Well,
we can undoubtedly find out.
Perhaps you could find out and let me know.
Yes, I mean, you may have seen the list of those who agree and approve it.
Yes.
And it ranges from APIL and FOIL, the Association of British Insurers, the International Association of Underwriters, and so on and so forth.
Yeah. So
there is a pan-industry or cross-industry agreement to the importance of rehabilitation. And in effect, the importance is obvious. For insurers, if a claimant can be improved or their recovery maximised, the ultimate damages will be less. And for a claimant, of course, recovery to a state as near as possible to that pre-accident is overwhelmingly to their advantage too. The practice generally, my lords, in relation to rehabilitation is for there to be a case manager instructed, either directly and solely by the claimant solicitors, or jointly by the claimant and defendant together. The case manager is generally a nurse or an occupational therapist by background. In this case, as it happens, there were two case managers, one having to be replaced following a complaint that was made against her. They were both nurses, registered nurses. They are not legally qualified. They have no specific training in safeguarding or statutory funding and the like. But their role, essentially, is to assist in the instruction of therapists, to recruit support workers and the like. Finally, in terms of the background position on a catastrophic injury claim of this nature, where a claimant lacks financial capacity, the capacity to make their own financial decisions, as this one did and does, a deputy is appointed by the Court of Protection. And it is, in essence, consideration of the interaction between these various parties that's before the court.
And the deputy's costs are form part of the schedule of special damages.
They do, my lord. Yes. As do, I should say, the case manager's fees. You may have seen at the end of our skeleton argument an issue canvassed that was raised by Master McCloud, specifically whether there's an alternative route to the claiming of the relevant costs, specifically as a head of damages. I'll deal briefly with that at the end of my submissions, but it's a matter that we say is of less appeal. It's a less attractive route to recovery of those costs than recovery as a cost per se. The issues
less attractive to whom?
Well, to the courts primarily, my lord, because what would result would be a judge without necessarily specific costs assessment expertise having to address the reasonableness and proportionality of costs that were incurred by the claimant solicitors. That with the existing regime, whereby the budgeting exercise and the detailed assessment exercise are carried out by specialist cost judges or judges with specialist cost knowledge. And we envisage or would suggest that those judges, the master, the district judge and the regional courts, are much better placed to assess the reasonableness of costs than a high court judge who may have many millions of pounds of other damages to assess at the same stage.
Well, I don't want to speak on behalf of either of my lords, but certainly as far as I was concerned, as a High Court judge, I seem to spend much too much of my time dealing with costs in one form or another, and indeed much too much of my time doing cost budgeting in one form or another. So I would yield every time to the expertise of a cost judge, but I think the days of saying that High Court judges don't know about costs is perhaps sadly a thing of the past.
Well, I couldn't begin to venture they don't know about costs, my lord, or that they're incapable of dealing with those matters. My point was that
they're not a specialist.
They're not a specialist, and it would be better for those costs to be dealt with in the round alongside other costs. You'll be aware in this case, my lords, that the respondent concedes that a tranche of the costs related to rehabilitation are reasonable and recoverable and costs of and incidental to the claim. So there is inevitably going to be some tranche of costs relating to rehabilitation that would properly form the subject of the budget, irrespective of your lordship's determination today. And we say, and it's a point really of procedure, but we say it would be better for the entirety of those relevant costs to be determined and considered at the same stage, rather than some hived off for consideration, perhaps by reference to different legal principles on a different occasion.
Can I just ask you about that concession, which you rightly identify, and indeed Master McCloud accepted? Does that really mean that there is therefore a big point of principle in this case? If it is accepted that some of these costs are recoverable?
Well, we say not, my lord. This is a point of some significance to us. The concession, in summary, and I hope not to misquote it, but the concession in summary is that it will be cost of an incidental to the claim.
Say again.
The cost of an incidental to the claim, so that is the cost recoverable under the Supreme Courts Act. Those costs will include costs incurred arranging funding for rehabilitation placements. That is conceded in my learned friend's skeleton argument, paragraphs 48 to 50. And the reality, we say, is that when one puts that into the context of what was actually done in this case, specifically, there was a meeting between both solicitors, the case manager, and the treating doctors, with a view to discussing the funding, and as a result of which funding was agreed. We say that essentially amounts to a concession that these costs can be recoverable, at least in part. To your lordship's point.
And therefore, what's between you is the defendant's outrage at how many hours were spent.
Yes.
And that's not a point of principle. That's just...
No, it's not a point of principle, my lord. And I should say this from the outset. We recognise, and it is not our case, that a claimant solicitor should be entitled to attend every case management meeting. That's just not the case. We recognise, even this point, that the court, at detailed assessment and on detailed review, may decide or determine that some of the attendances in this case were not reasonable or proportionate. We recognise all of that. Our point is simply that a blanket ban, essentially, on solicitors attending the case management meetings is quite clearly inappropriate, particularly given the concession that was made and given the way in which, in this case, the agreement as to funding was obtained. So I'm in agreement with the Lordship, essentially. Our position today is that not all costs are necessarily recoverable, but there cannot be a blanket ban as a matter of principle on this type of attendance.
And when you refer to the concession, you're referring, you say, to paragraphs 48 to 50 of Mr. Davis's helpful skeleton argument.
Yes, let me, if I may, just be quite clear, my Lord. It's page 36 of the core bundle.
Yeah.
At paragraph 48, there is an acceptance that costs of and incidental to proceedings, that being the legal test, however applied, can include the cost of interim remedies. And then at 49, the respondent accepts that steps taken to secure interim solutions may properly be considered costs of and incidental proceedings and may include securing interim payments on the one hand, and then secondly, securing agreements from a defendant for appropriate funding, whether pursuant to the code or similar. Now, the reason we emphasise that, my lords, is that the most difficult stage of this claim has been each occasion on which there's been a step down from one facility to another and then ultimately into the community. And there have been funding consequences to each and every one of those steps. Generally, the costs increase because residential care is often cheaper than care in the community where carers have to be recruited directly. And self-evidently, the initial NHS-funded care was free. And the way in which those funding issues have been managed in this case, certainly on at least one occasion, was for there to be a meeting attended by the defendant solicitor, the claimant solicitor, and the case manager. And it was as a result of discussions at that meeting that funding was secured for the next step-down placement. And that's detailed within the statements. I can take you to them if need be. But that really is the point or the import, we say, of the concession. That concession rightly having been made, we say that is a concession amounting, in essence, to recovery of the costs, in principle, subject to reasonableness, proportionality, and so on.
Yeah.
The two issues before the court in relation to the appeal are firstly this matter of principle, whether as a matter of principle costs can only be claimed inter partes if they are incurred in the progression of litigation. Was that the appropriate test? And then secondly, and perhaps overlapping with the first, if so, was the master right to find that the relevant costs, specifically this tranche of costs in their entirety, did not and would not progress the case and were therefore non-recoverable inter partes. Our position on those two issues, in summary, is this. We say that the master was wrong to find that costs can only be recovered if progressive of the litigation. The true test, we say, as to whether such costs are of and incidental to the claim is whether they are of use, service, and relevance to the claim. And while it may be said that the word or term progressive is some form of judicial shorthand for the Gibson criteria, to which I've just referred, we say in reality they amount to different things, and the test that she applied was wrong. Secondly, our case is that if the test imposed was appropriate, that the judicial shorthand is a reasonable summary of the Gibson principles, then she was wrong to find, as a matter of principle, that the entire category of expense is non-recoverable. We say that's inconsistent with the concession I've already referred to, inconsistent with case law, and finally inconsistent with established practice at the coalface, to use my learned friend's phrase. In terms of a remedy, my lords, given that the claim is now settled and that we are well past matters relating to or covered by cost budgeting, we suggest or seek an order that the costs of attending MDT meetings or rehabilitation meetings are recoverable, subject to the usual controls of reasonableness, proportionality and attribution. And we observe that the court could, if it so wished, further caveat that order by requiring or stating that such costs are recoverable subject to demonstration of use, service and relevance to the claim, those being the Gibson criteria, which we say are determinative.
What is the point, if that is the principle, of having weekly meetings with the two deputies?
Well, my lord, the weekly meetings were an account, or rather an explanation for the costs that were claimed in the estimated costs. And I think I have to concede that the explanation for that, or the justification for that, is less compelling than it might be in relation to the justification for earlier interventions and other interventions with the case manager of the type that I've already referenced.
Accepting that something is less compelling is not an answer to the question I asked you, but I understand the point. I mean, how does meeting a deputy, the deputy is there to deal with the unfortunate consequences that this person lacks capacity, and we'll deal with that. And of course, the costs of the deputy are recoverable in damages, so you need to know what those are. You need to meet the deputy for those purposes. But a weekly meeting...
It's not primarily meetings with the deputy, it's primarily meetings with the case manager.
No, but there were 2 hours, 3 hours of meeting, according to what Master McCloud...
Yes, indeed. But my lord, that was not suggested as being, this will happen each and every week. It's an average over the weeks. There will be some occasions in which there's more time spent, some occasions less. On average, that is the time that it's said will be spent. And it's perhaps, and I'll come to the specific circumstances of the case, my lord, but the case involved a very, very fractious relationship between the litigation friend and the claimant's mother. And that manifested itself in the form of a series, multiple safeguarding complaints, threatening legal action, complaints from the treating medical establishment, complaints from the instructed care agency, all were made and raised and had to be dealt with by the claimant's representatives. And there was inevitably, and this continued well after Master McCloud's cost budgeting. I've given an example already of the application to replace a litigation friend, but there was an ongoing need to address all of those matters, all of which potentially would have capsized the rehabilitation or interrupted and interfered with this man's progress on discharge into the community. So we do say that in the particular circumstances of this case, and it has to be case specific, in the particular circumstances of this case, it was reasonably necessary and would have been reasonably necessary for the ongoing interaction between the claimant's solicitors, the case manager, and the deputy. But it's a point, to an extent, my lord, that we raised earlier on, or that we discussed earlier on. It may well be that at detailed assessment, those costs were found to be inappropriate OTOs, or perhaps an undervaluation.
Or caused by something else other than the accident.
Indeed.
You know, for example, I mean, it's not immediately clear to me why those would be the responsibility of the defendant. Fine, they caused the catastrophic injury, without which there would be a need for a deputy. But if it's a mother and another litigation friend who've fallen out, that's...
Well, the answer, my lord, we say, is that you take your claimant as you find them.
Yeah, yeah.
If as a matter of reality, mother lives in Wales, claimant and partner live in Cambridge, and there is then a dispute as to where the appropriate step-down facility is for rehabilitation, that is something that naturally falls upon the defendant. This is just it's a facet of life and catastrophic personal injury claims that wriggles will arise along the way that have to be determined or dealt with, and those are specific to each individual case.
Thank you.
I mentioned, my lords, that I was going to make three provisional observations, if I could, overarching observations.
Yes, so this is your part two of your
Indeed.
Your second heading, your three observations, yeah.
The first is one that I can deal with very briefly because I've already addressed it, perhaps at length. But I just reiterate that we don't argue that a solicitor is and should be entitled to attend every case management meeting or multidisciplinary meeting. It is very much a fact-specific issue. And the paying party, we say, will not be left without protection if the appeal is allowed. On the contrary, and to quote from the Roach case, to which I'll come, he will still have the protection of the evaluative assessment powers conferred by statute and subordinate rules on the cost judge, i.e. detailed assessment and the controls that can be exercised then. The second of the three observations is that Master McCloud, in her judgment, made a number of points with which we want to be associated and which we will endorse. The first, you may have seen, was her approval and consideration of the benefits of alternative dispute resolution in high-value cost cases. This, I think, was the first occasion on which she had ordered the parties in a large cost case to attend and conduct ADR under the guise and remit of specialist cost lawyers. And that led to a very successful outcome, specifically agreement of over £1 million worth of costs with, I think, only £60,000 left in dispute. So we endorse the observation and the action that she took there. The second observation that she made, which we would endorse and agree with, relates to the phasing of the costs. And it's potentially an important one because much is made by the respondent, much was made at the hearing by the respondent, and may be made today, of the assumptions provided for in the CPR as to what falls in what phase. And the difficulty we have with the whole issue of phasing is that we say the precedent H form is very much a blunt tool. It's designed to cover costs in every sort of case, and it is a form prepared many years ago, and we say that in the particular circumstances of this case, none of the phases readily fit the sort of cost with which we're concerned. And you may have seen from the transcript of the hearing that there was a discussion between Master McCloud and the claimant's cost lawyer as to where ordinarily these sorts of costs would be placed. He had placed them within the issues and statements of case phase. And interestingly, the BCX case, which we'll come to, relied upon by the respondent, in that case, the same costs were put within that phase, the issue and statements of case phase. But there was a discussion.
In BMX, it was in that phase.
It was in that
too.
phase, yes. Lord, yes. I think Mr. Brighton, the claimant's cost lawyer, noted there was a difference of approach amongst the masters as to which phase would be appropriate. But the point made by Master McCloud in her judgment is that in reality none of those phases are appropriate. And her view was that if she was wrong on the matter of principle and these costs were recoverable properly, then they should go into a separate phase. And we endorse that approach because it seems to us that they don't readily fit into any of the pro forma stages within this pro forma precedent age.
When you say a separate phase, you mean a different?
I do.
I mean creating a new category?
Yes, that was the approach.
That's fantastically unattractive, you'll understand. I mean, cost budgeting is a blunt tool, and that's how it works. You can't have different cost budgeting forms for different types of case, because then there'd be an argument about which is the appropriate form.
Well, one could see, my lord, that it could perhaps, I would, my immediate response, say it could go in a contingency or in as a contingency. The difficulty, of course, with that is that under the law as it stands, contingent costs are not appropriate unless they are likely to be incurred.
But this isn't contingent because
no,
it's going to be incurred.
It is.
On your case.
It is.
So it's not contingent. I mean, even if it isn't a precise fit, I rather took the view when looking at it that issues and statement of case was the least worst option.
Well, I think you're right, my lord. I think our point is that it is the least worst option. The reason
why does it matter?
Well, it matters, my lord, to this extent. The respondent relies very heavily on the assumptions, the pro forma assumptions, within the practice direction as to what appropriately falls within the issue and statement of case phase. And it rightly highlights and identifies that there is no reference to case management meetings or rehabilitation and the like. Now, that is something that can be got around because, of course, the precedent H form allows for further assumptions to be recorded. It's not just the pro forma assumptions. Right. But the reason I endorse Master McCloud's observations as I do is that we say the pro forma assumptions within the practice direction have no bearing today on whether or not these are reasonable costs. It's a function of a blunt tool, so to speak, and nothing more.
Okay.
The third and final general observation I make, I can take briefly, and it's this. This is not, we say, a discretionary case management decision of the type that an appellate court should be slow to consider. It's very clear from the approach that Master McCloud took, both during the hearing and in her judgment, that she was seeking to determine a novel point of principle and to then pass the matter to yourselves for a definitive and determinative ruling. And I can quote very briefly from the part of the transcript where she addressed this, and she said this: what my present view is...
Hang on, do you want to give me the reference?
Yes,
that's in the
Supplemental 108, my lord.
Say again?
Supplemental 108. The fourth paragraph down on 108. My present view is that I'm going to knock this on the head one way or another and actually write a decision swiftly setting out my views, because there does not seem to be any reported decision on this, and if whichever side is unhappy appeals, then so much the better, in the sense that we can get some appellate authority on whether I'm right or wrong on whatever conclusion I reach. It sounds like there's an uncertainty as to practice, at least, because different people are having different perceptions of what is being included and what is not. So it is clear, we say, my lords, that she was seeking to determine a point of principle. This is not a conventional case management, discretionary type decision with which she should be slow to interfere. This is a point of principle where she was specifically encouraging you to revisit and provide a determinative ruling on the point.
Yeah. So those are the three observations.
Those are my three observations, my lord, yes.
Yeah. So then we go into the specific grounds.
We do. The first ground is that she misapplied the relevant test. We say, in summary, that the test is not whether costs are progressive. In terms of her judgment on point, it was raised, this point of principle was raised by the defendant. I could ask you to turn, please, to the core bundle, page 46, which is part of her judgment.
Yeah.
You'll see at paragraph 5, she records the defendant arguing that as a matter of principle, such attendance charges ought to be ruled as inadmissible. They are not progressive litigation, any more than, say, lawyers attending medical treatment appointments. And then her determination is at paragraph 10 on page 47. She accepts the defendant's arguments that it is a general principle that costs are legal costs which are incurred in the progression of litigation. They may be pre-action. They may be reasonably incurred but found in hindsight not to be useful. Yet such costs can still be progressive, even if they rule out something which are not then pursued. Costs which are inherently non-progressive are not, in my judgment, costs properly claimable in a budget between the parties. That's a relatively short statement within her judgment of this point of principle. There's no reference to any underlying authority, rule or statute. And we say it's perhaps explained by the manner in which the point arose. This point had not been foreshadowed in the defendant's written submissions. And it's perhaps important to highlight that the written submissions, although calling into question the relevant costs, did so only on the basis that they were excessive, unreasonable and disproportionate. They did not raise objection on any point of principle at that stage. In terms, my lords, of the relevant statute, I needn't take you to it. It's section 51 of the Supreme Court Act. It's at page 4 of the authorities bundle, your records or your note.
Yeah.
A litigant can recover the costs of and incidental to litigation. There are various factors set out in the civil procedure rules as to the exercise of the discretion. Again, I needn't take the lordships to those because you'll be well aware of them or familiar with them. It's rule 44.2 at page 9 of the authorities bundle. And it is right to say or to observe that nowhere within the White Book is there any support for the suggestion that costs have to be progressive in order to be recoverable into parties. The White Book itself does cite with approval the case of Reed-Gibson Settlement Trust. And if I may, I'll take your lordships to that fairly briefly. It's in the authorities bundle, page 19. This was a chancery case relating to the administration of a trust, and an issue arose as to whether or not costs incurred prior to the issuing of a summons could be recoverable, and more specifically, whether those costs were of and incidental to the proceedings. And at the bottom of page 26, we have the so-called Gibson criteria, the 3 strands of reasoning that were teased out by Sir Robert McGarry after an extensive review of the case law. These were, or rather these are, criteria that have been approved and referenced in numerous cases since. It's at the very bottom of page 26, little h, or rather paragraph h, section h. There were thus 3 strands of reasoning: that of providing of use and service in the action, that of relevance to an issue, and that of attributability to the defendant's conduct.
When it talks about the defendant's conduct, it means what? The defendant's conduct originally gave rise to the cause of action.
Yes. Yes. Costs which don't arise, whether directly or indirectly, from the defendant's conduct, we would have to accept not recoverable.
In fact, what Sir Robert McGarry was talking about there was an observation about the judgment of Lord Hanworth in Frankenberg.
Yes, he was. He was seeking to tease out from that judgment those three separate observations. Yes. But essentially, my lords, since the Reed-Gibson case, these three strands have been adopted again and again. And we say they are
Is that in the White Book?
Reed-Gibson?
No, the adoption of it again and again.
Well, I will take you to two separate cases in which they are adopted. In the White Book, the reference in the White Book to this case and the approval of it comes at page 1356, which is page 11 of the authorities bundle. And it's the third paragraph on page 11 of the authorities bundle. You'll see there the reference to Reed-Gibson Settlement Trust. I didn't read it out.
Yeah.
Our point, in essence and in summary, my lords, is that trifecta, those criteria are essentially the lodestone by which the court assesses whether or not costs are of and incidental to the proceedings. So use and service on the first hand, secondly relevance, and thirdly attributability. And we say there is no room for a judicial shorthand of whether or not costs are progressive. We say that doesn't accurately and properly reflect the Gibson criteria. And that being the case, the judge having chosen to determine these costs on that basis, she erred.
Did she allow in any costs going forward for this heading?
Yes, she did.
So she, I entirely understand it's not your fault because you didn't write the judgment, but there's this principle set out, which, if it was taken to mean what I think you take it to mean, you wouldn't then have got any costs going forward.
Well, I agree. And that is the difficulty we have with the judgment and with the respondent's position today, my lords. We don't understand a blanket ban, essentially, and I can call it nothing more than that. We don't understand a blanket ban on the recovery of these costs when, firstly, it's conceded costs of this type are necessarily of an incidental to the claim, and secondly, where the master herself allowed for some of them.
What did she allow? 16,000 or something, wasn't it?
Yes, it's helpfully set out in my learned friend's skeleton argument, as it happens.
Yes, I couldn't find it in the paper.
It works out as being about 3,100 for not drafting the schedule, if I can put it that way, my lord.
Right, thanks.
That's your paragraph towards the end of your skeleton.
Very
It's 65.
Very end, my lord, yes.
Yeah.
It's slightly complicated by the fact that the disbursements were agreed, so the figures on the face of the judgment don't necessarily tally up with the figures one might expect. That's because they exclude disbursements.
So doing the best you can, it's the calculation at 65 to 67.
Oh, I think it is that calculation, my lord.
Yes, I agree with that.
Sorry to interrupt.
No, it's right to observe as well that Master McCloud made the point that if she were wrong on the matter of principle, then she would wish to perhaps scrutinise more closely the level of costs that were claimed, and we'll probably be looking at reducing them. We have no issue with that, of course. It goes back to the point I've made on a number of occasions already.
Is the point, Mr. Barnes, that it rather depends on exactly how you formulate it, because the point of principle could be said to be simply that if there are costs of attending that meeting, then that doesn't make them recoverable. And that would be right. Merely because the costs are costs of attending the relevant kind of meeting doesn't turn them into recoverable costs.
Well, I agree. I agree, my
I
lord.
know you do.
We're not seeking to argue for.
I understand. But isn't that the point of principle that the judge was deciding, effectively? That's right. That doesn't mean that you can't have some costs, but merely describing them in that way isn't enough to turn them into recoverable costs.
No, my lord, the point that we see her having determined is this, that a solicitor, a claimant solicitor, cannot ever recover the costs of attending those meetings, which is a different point.
No, it's not. if the point is simply that you can't recover the costs if all you ever say about them is that they're the cost of attending the meetings, then that's right. Well, your point is that when you attend those meetings, you may well be doing things which are recoverable, which no one disagrees with. But equally well, merely because their cost of attending a meeting doesn't turn them into recoverable costs.
Well, I'm struggling with that to this extent, my lord. If one takes the example of the agreement of funding, there was a meeting set up with the case manager to discuss the rehabilitation, to discuss the step down, and to discuss the funding that would be necessary for that. There is no doubt that that would be a case manager meeting, so to speak. Now, it having been set up for the purposes that it was, and it having included discussion of matters which it is accepted are relevant to and of an incidental proceedings, we struggle with any suggestion that necessarily such meetings cannot fall within the of an incidental to the proceedings, that necessarily such costs cannot be recoverable.
But that's because you've added extra words in to describe the meeting, which have made them a meeting which is recoverable. And I'll assume that in your favour. But that's not because it's just a meeting with the case manager. That's because it's a particular sort of meeting with the case manager, which leads it to be recoverable. Which, as far as I know, no one disagrees with.
Well, I think to be fair, the respondent does disagree with that, my lord. I think it was the respondent's case advanced at the hearing that, as a point of principle, attendances on the case manager at case management meetings or attendances at rehabilitation meetings could not be recoverable and were not recoverable inter partes. And that was the point we believe the master determined, and she determined against us. And our position essentially is that that determination leaves no shade for the sort of point that you've just articulated. Because the way that cost budgeting is approached is a fairly rough and ready way. Detailed assessments themselves are fairly rough and ready. And if there is an existing determination of principle that a claimant solicitors and defendant solicitor, I should say, because they attended as well, if there's a determination of principle that the costs of attending those meetings are not of an incidental to the claim, then that will bite whatever the subsequent discussions. That I hope, is a response to the point that the Lordship made. Moving on in relation to the legal test, we do rely upon two cases in relation to the costs of attending inquests. And on both occasions, the courts gave consideration to whether such costs could be of and incidental to the claim more generally. The first is a case of Roach versus the Home Office. It's at page 33.
This is Roach and Fullick.
Yes.
Is the other one.
Correct, my lord, yes.
How do we derive assistance from that?
Well, because in those cases, there were comments made to the effect that, first of all, one has to adopt the tripartite test. I've already referred to the Gibson criteria.
Yeah.
Is it use and service? Is it attributable? And is it relevant?
Yeah.
A test that we say is different to that of progressiveness or progression. And secondly, there are observations made there that any sort of blanket ban or overarching refusal to allow costs of a certain type would be an inappropriate fettering of the court's discretion under section 51. In essence, in the Roach case, my lord, what was argued on behalf of the paying party, the defendant, was that costs of separate proceedings could never, as a matter of principle, be recoverable in another claim. And after a very lengthy review of the relevant authorities, Mr. Justice Davis, as he then was, rejected that contention. And thought it, in essence, and my words, not his, essentially inappropriate fettering of the discretion that arose under Section 51.
So which passages do you want to take us to in Roach?
It starts at page 33 of the judgment, my lord.
Yeah.
And the paragraph 29 references the Gibson criteria. That's on page 41. And then paragraph 40 on page 46. You'll see there that the recording of Mr. Morgan Casey's proposition advanced that such costs can never be recoverable. And then at paragraph 41, if I could just read out the first couple of sentences. He found it impossible to extract such a rule. He said this: on the contrary, the wide wording of the section, that's section 51, as set out in subsections 1 and 3, is inimical to there being such a rule or such a fetter on the court's powers. And essentially, we adopt that, and I suppose substitute these words or these arguments in their place. We say that the wide wording of section 51 is inimical to there being a rule or principle requiring that costs be progressive, thereby fettering the discretion of the court. And secondly, if and to the extent that such a principle does exist, then the wide wording of section 51 would again be inimical to any proposition that all costs of attending such a meeting would be non-progressive, irrespective of the circumstances. Because we say that to do so would again be to fetter the statutory discretion of the court. The last observation from that judgment, if I may, my lords, is at the very, very end, paragraph 62. Because, this is page 51 of the bundle, authorities bundle, he was asked or invited to lay down guidelines for the assistance of cost judges and of those who practice in this area. And over the page, towards the end of section A, I think this would be unhelpful and I decline the invitation. It seems to me that the discretionary regime available to cost judges in this context and the application of section 51 wouldn't be advantaged by further guidelines. Each case should probably be decided by reference to its own circumstances. And then, very last sentence, better I think to leave it to cost judges to decide each case on its own facts by reference to section 51 and the subordinate statutory rules, and having regard to the principles indicated in the settlement trust case. And that in essence and in summary, my lords, is the approach that we say the master should have taken in this case, the master should take in other cases. They should have regards, first of all, to section 51, are these costs often incidental? Then look at any subordinate statutory rules or rules of court, if and to the extent that they apply. And then lastly, apply the principles in Re Gibson when determining whether or not those costs are reasonable and recoverable inter partes, subject, of course, to the overriding controls, if you like, of reasonableness and proportionality. The Bullock case, my lord, is a similar case, again relating to a death in custody. I think I should highlight one aspect of it which could be said to be against my claim and my arguments. And it's at paragraph 69 on page 72. And starting on the third line, the court said this: the costs incurred by the claimants in connection with the inquest must be relevant to issues in the civil claim to be recoverable. That requires identification of outstanding issues which are necessary to the civil claim, in respect of which the claimant's case would be advanced by participation in the inquest. I highlight that point, my lords, because as I say, it could be said to be against the general thrust of this ground of appeal. But it needs to be read alongside the rest of that paragraph and paragraph 70. And at paragraph 70, the judge says this: performing the exercise of identifying and evaluating the relevance and utility of the civil claim or participating in the inquest may be onerous, but in my judgment is necessary. It may be necessary and would be prudent to stand back to consider whether the total costs of participation are proportionate to its utility and relevance to the outstanding issues. So again, notwithstanding the reference previously to advancement, the injunction from the court is very clearly that what needs to be done is to address the Gibson criteria: use and service, relevance and attributability. And in summary, in relation to ground 1, my lords, it's our case that the judge erred, the master erred, and unlawfully fettered her discretion in restricting her consideration of costs to only those progressive of the litigation. Can I move on then, my lords, to the second ground, if I may?
Yeah.
This is, if you're against me on the first ground and you find that there is a general principle that costs have to be progressive, we say then that she was wrong to find that these costs were not progressive. In particular, she was wrong to
could
find...
also work the other way, couldn't it? I mean, you might be right about ground 1, but if it's a question of language, and language only, in relation to ground 1, or if we thought it was language only, then you'd still need to show that the principle was wrong. If she held as a principle that attendance at these meetings was irrecoverable in principle, then regardless of ground 1, you'd still need to demonstrate that that was wrong.
We would. The causative relevance, I suppose,
yeah.
My language of her error in relation to ground 1.
I understand how you put it in relation to ground 1, but ground 2 apply. What I'm saying is ground 2 applies in any event.
Yes, it does. It does, because in essence, my lord, that there is scope for an argument by the defendant, by the respondent, that irrespective of the legal test, which of the two it should actually be, these costs wouldn't be recoverable either way. So I recognise that. And in relation to the second ground, we rely broadly on 3 matters. Firstly, the particular circumstances and features of this case. Secondly, the importance of rehabilitation generally, and specifically in this case. And thirdly, the actions and the involvement of the defendants in this case, and more widely, particularly and specifically in relation to rehabilitation. And what I'll do, my lords, if I may, is run reasonably quickly through those 3 points and then seek to draw together a series of propositions that we say follows from them. In relation to the evidence before the court, my lord helpfully indicated that you had read the witness statements, and I needn't take you through them at length. But if I may, I'll highlight certain paragraphs or certain observations from those statements. Mr. Roberts, the claimant's solicitor, his statement begins at page 3 of the supplemental bundle.
Yeah.
And as I say, I'm not going to take your lordship through every paragraph by any means, but I would, if I may, highlight paragraphs 8 and 9 initially. Paragraph 8, he reiterates his desire to work collaboratively and to prioritise rehabilitation over obtaining medical legal evidence. And then at paragraph 9, it's his view, and it's long been his practice, that the claimant's solicitors should retain oversight of the case management and rehabilitation provided to the claimant. They are, in essence, the commissioning body for all treatment. They are responsible for the expenditure of very substantial sums of money on the part of the claimant. Those sums of money, my lord, in this case, amounted to around £900,000 by December last year.
Are they responsible for commissioning, or is the deputy responsible for commissioning as a matter of law?
Well, the deputy wasn't appointed for a large part of that, of those proceedings. For a large period of time, or a significant period of time, there was no deputy in place, my lord.
Well, once there's a deputy in place?
Well, once there is a deputy in place, the monies are paid over to the deputy, and they sometimes then enter into contracts, for example, with the support workers, if they are directly employed. And I recognise that at that stage, the responsibility for contractual arrangements, for example, would lie with the deputy. The difficulty for claimant solicitors, though, my lord, is that they cannot simply pass those matters over to the deputy, because it's clear from Laughlin and Singh and other cases since then that the court on the assessment of damages can have regard to the costs incurred to date and disallow some part of them, if and to the extent that they're considered to be inappropriate. And the deputy themselves will not have the same overall knowledge of the case and of the actors responsible, the actors involved, so to speak, and of the issues arising in the case. So there is a need for the claimant solicitors to retain that oversight, even once legally there may be a specific commissioning on the part of the deputy, because the deputy is less concerned with the issue of whether or not steps taken are reasonable and thereby recoverable when it comes to the assessment of damages. But as I say, I'm told that the current waiting time for appointment of a deputy in the Court of Protection is somewhere between 6 and 12 months, depending on the court and the part of the country. And that being the case, in every catastrophic personal injury claim, we say there is likely to be a period during which the commissioning part is undoubtedly the claimant solicitors, on a legal and a non-legal basis.
Can I just make sure I've not misunderstood? In paragraph 9, the first sentence, when it says case management, it means the medical case management, not the legal case management.
Yes, that's correct, my lord. Yes. The case management under the aegis of the clinical case manager, rather than the legal case itself. Moving forwards through the statement, if I may, paragraph 17 on page 8. There is reference to the claimant's vulnerability, and vulnerability is often a feature of traumatic brain injury cases, but a particular feature of the incident case. And Mr. Roberts notes there that the claimant was particularly vulnerable. He was suggestible. Dr. Grillo, who was the treating neuropsychologist, reported there that he'll essentially say whatever he thinks wants to be heard. The MD team at Little B have raised concerns about his welfare as he's vulnerable to exploitation, and they feel that he's being manipulated and controlled by his family. They note again that he's suggestible. And then at Little C, there is a concrete example, I suppose, of the claimant's vulnerability. And whilst in Askham Village, which was the last of the step-down rehabilitation facilities, the claimant was contacted by an unknown person on Facebook and was persuaded to expose himself and pleasure himself while on Facebook. Screenshots were taken. His partner was contacted and advised the photos would be circulated unless payment was received. A really very serious incident. The matter was reported to the police, which shows how vulnerable the claimant is. What followed that, my lords, and it's not before you, but it's a matter of record from the Court of Protection, was a specific consideration of and determination of whether or not the claimant had the capacity to access the internet and social media. And you'll understand why that was seen as important, given that very serious incident. But the point we make is that this is a man now, and was a man throughout the course of proceedings, who was extremely vulnerable.
This is all miles from the point of principle. Because the point of principle would apply whatever the circumstances of the claimant.
Yes, but that is the difficulty we have with the point of principle. The point of principle is a blanket ban, my lord.
I understand that.
And
so it would apply whatever the particular circumstances.
Well, indeed, and
so it's a question of whether that is right as a matter of principle, but you can't establish whether it's right or wrong as a matter of principle by reference to the particular circumstances of this particular case, can you?
Well, we say we can, my lord, on this basis, that the court can and should have regard to features of catastrophic personal injury cases when considering whether or not it's right to allow these costs. The background to the whole issue of rehabilitation, my lord, is, as I say, this cross-industry agreement as to its appropriateness and merits.
We get that. We get
that. And there will be cases where the need for it and the difficulties arising from it are aggravated by factors or experiences just such as this.
That may be, but it doesn't help with whether or not, as a matter of principle, these costs are recoverable.
But what it does help with, my lord, is assessment of the Gibson criteria, because when one is looking at whether or not these costs and the costs of dealing with, for example, issues such as this, are those costs of use and utility and service to the claim, are they attributable and are they relevant? We say that having regard to the specific vulnerability bears directly on the Gibson test, because one is looking at whether or not the trial judge will be assisted by evidence in relation to and the work done dealing with issues such as that. So we say, my lord, that when the test is applied and when the relevant parts are considered, the individual circumstance of the claimant does fall to be considered.
Well,
You made your observation, my lord, and in those circumstances I needn't take you at length through the rest of Mr. Roberts' statement, because he essentially continues to reiterate just how difficult the claim has been, just how important it's been to coordinate the case management and the extent to which the family situation and vulnerability has required him to attend with the case manager on numerous occasions.
Some of those particular incidents might be said, whatever let's assume you're right about the principle, it might be said, well, those aren't recoverable because they're attributable to completely separate events.
Yes, it might be, my lord, and I hope I've conceded immediately that there will be...
No. The premise of my point was accepting that you're right as a matter of principle.
Yes.
But somebody could say, well, that particular event, the costs generated by that particular event are not actually recoverable against the defendant because it's a separate event, incident,
yes,
what have you.
Well, I agree with that, my lord. That was why when I spoke about the remedy, or one of the remedies open to the court today, it would be to refer these matters on to the detailed assessment, essentially, with the review and detailed assessment to consider or to include consideration of use and service, relevance and attributability.
So therefore that also wouldn't go to the point of principle.
Well, the point of principle, my lord, is governed by and determined by the Gibson criteria. That is, in my submission, the legal test as to recoverability of the costs in this case.
Yeah. All right. Well, as I say, I mean, if there are any other particular matters in these statements you want to show us, then fine. But at the moment, I'm not persuaded that they're going to make a difference to our ruling as a matter of principle.
Well, let me just then, my lord, highlight, if I may, one observation from the case manager's statement. And it ties in up. I should make the reference, or give your lordships the reference, because it ties in with points I made earlier on. It's at page 53, and it's a statement from Lisa Barnes, who is the claimant's, or was the claimant's case manager.
Yeah.
Initially. And paragraphs 28 to 31, she discusses a particular meeting that took place with the claimant solicitor and the defendant solicitor to discuss discharge from the Chantry to Askham Village and the funding that would be required to manage that. The reason I referenced this earlier on, my lords, is that this ties in, we say, with the concession made by the defendant, the specific concession that consideration of funding of rehabilitation placements were costs and would be costs of an incidental to the claim. So to that extent, the principle, and only to that extent, the principle was conceded. And I highlight these paragraphs because it's clear in my submission that the way in which those funding decisions were reached was by way of a meeting with the case manager and the two sets of solicitors. And we say that this is fatal, in essence, to any overriding principle that the costs of such meetings cannot be recoverable. It's conceded that work has to be done, but it's of an incidental to the claim, and it would be nonsensical if you could recover those costs had they followed a meeting between just the solicitors, or had they followed a telephone discussion or correspondence by post. But you can't recover them if, sensibly, that meeting takes place with the case manager themselves. So that is the reason I highlight that part of Lisa Barnes' statement. I should say it reiterates comments within Mr. Roberts' statement, but it's most conveniently set out there at page 53. Can I move on then, my Lord, to the second point that I said I would raise and rely upon?
Yeah.
In relation to whether or not these costs can be seen as progressive, if that is the appropriate test. Were these and are these costs progressive? We do rely very strongly, my Lords, on the Rehabilitation Code and the Serious Injury Guide. I've put the relevant paragraphs within our skeleton argument, but I do emphasise this. The Rehabilitation Code has been in place now, I think, since 2005. It's gone through various guises. It's been the subject of consideration by the court in the case of Brown and Alexander, and it has, to my knowledge, never been seriously called into question. And it does mandate and require the parties to involve themselves in the sort of rehabilitation with which we are concerned.
Brown and Alexander was the case about whether the subsequent reports were covered by privilege.
Yes, that's correct, my Lord, yes.
Yeah.
Yes. The Serious Injury Guide, which starts at page 120 of the Authorities Bundle, is really an adjunct to the Rehabilitation Code. It was, or rather it came to be in a rather or slightly different way.
So, sorry, just to be clear, the Rehabilitation Code, you're going to tell me who published that, and you say that's published, that's 2015.
Yes, it is. The latest version is 2015. I think I'm right in saying the first version was 2005. Will you give me a moment? I'm helpfully informed by my junior, my Lord, that the working party jointly agreed the wording of the Rehabilitation Code, and then it was published on the website of the International Underwriting Association.
Thank you. And the Serious Injury Guide?
The Serious Injury Guide is somewhat different, my Lord, because this is a protocol, so to speak, that was agreed and has been agreed and signed up to by individual insurers and claimant solicitors, and I think defendant solicitors. Yeah. There's a working party which came up with it, and thereafter there was specific signatories to it. Right. And it's interesting, my Lord, we say, because it's very prescriptive as to precisely what is required and of the sort of work that will be expected. And I can quote, for example, from page 130 of the guide, where there is reference to open book rehabilitation best practice. Effective dialogue concerning rehabilitation progress and related challenges are a central part of case planning under the SIG. The defence insurer lawyer should be encouraged to attend periodic meetings, conference calls with the case manager and claimant lawyer to provide an oral update on rehabilitation progress and current rehab goals and objectives. And it's relevant, my lord, to this extent. What is envisaged by that, and has been the uniform practice of a large part of the industry for a number of years now, is the high-level involvement in case management and in the claimant's rehabilitation, not only of the claimant's solicitors, but also of the defendant's solicitors themselves. It being recognised that there are huge benefits to both parties in so doing. And when the court is addressing the issue of whether or not the costs with which we're concerned are progressive, we say this bears directly. There is agreement across the industry that the sort of work that was done is appropriate and should be encouraged and should be fostered. So we rely specifically on that, my lord, on that extract from the guide. The other extract from the serious injury guide that we rely upon, page 128, paragraph 6.7, the parties should seek to agree the frequency of meetings or conference calls with the case manager, if such meetings or calls are appropriate. I emphasise they are not always appropriate, but if they are, they should be arranged, and it's clearly envisaged that that would be appropriate. And then lastly, and it's really the preamble, paragraph 1.2 to that guide.
Sorry, where were you reading from just now?
Forgive me, my lord, it's paragraph 6.7, page 128.
Yeah.
The parties should seek to agree the frequency of meetings or conference calls with the case manager,
Yeah.
if such calls or meetings
And then you were going back to the start.
are appropriate. And then I was just making the general observation, and it's perhaps OTOs, that collaborative working is very much endorsed. Paragraph 1.2 on page 124. Collaborative working should start at the beginning and continue throughout the life of the claim with the objective of achieving maximum or maximising rehabilitation opportunities. A feature of these cases, my lords, is that the rehabilitation is very much an ongoing process. It doesn't end at such a time as the claimant is discharged into the community. If there is a possibility of further improvements such that the care can be reduced, then that's, again, very much in the interest of all parties to push towards such an outcome.
Mm-hmm.
So we rely strongly upon that guidance. In terms of how this matter is being dealt with at the coalface, my lords, the defendant makes reference to the case of BCX, which was a detailed assessment of own client costs carried out by Master Brown. Now I believe Master Brown. It's slightly different in that in that case, the indemnity principle applied and the client hadn't attended. It was an issue about recovery of a shortfall of costs from the claimant himself. But we say, my lord, this is in fact an authority very much on all fours with the propositions that we're putting forwards today. And if I could ask you to turn, please, to page 201 of the authorities bundle, I can maybe demonstrate the point by reference to the judgment. This, as I say, was very much a judgment at the coalface of costs. Firstly, we'll see at page 200 that this section to which I'm going to refer is dealing with the issue and statements of case phase, and that's the point I made earlier on, that there is evidence in other cases of these costs being lumped into that phase. And then at page 201, third paragraph down, there is criticism there of the substantial amount of unreasonable time associated with case management issues, internal discussions, and a claim for multiple fee earner involvement in certain activities. There is a note that solicitors need to keep abreast of developments relating to the claimant's care, treatment and rehab, and they were reasonably involved in the appointment of case managers. And then we say, crucially, I accept that in certain cases, attendance at MDT meetings can be reasonable, where, for instance, the claimant is to be or is being treated outside the NHS. It may be important to ensure that there's clarity about interim payments and the funding of care. However, the level of involvement in this case was unreasonable. And that really, my Lord, is, we say, strongly consistent with our case.
Can you read on just the end of the paragraphs?
Yes, of course. Of course. I have not located in the papers any explanation to the claimant that such costs may not be recoverable from the defendant. That's an issue with the own client costs. Moreover, I have difficulty seeing what solicitors would have been able to contribute to the MDT meetings in this. Nor, it seems to me, did the solicitors need to be at the meeting in order to find out what had happened. The notes of the meetings were provided to them. If there were issues or concerns about recoverability of costs associated with particular recommendations of treatment, the case manager would, of course, or could, of course, rather, communicate with solicitors and vice versa by email about this.
So your point is, he's not ruling it out as a matter of principle, he's saying it's all a question of quantum.
Yes.
Which there are parts of Master McCloud's judgment which might indicate the same.
Well, indeed, my Lord, but this, I suppose, is the concern which overrides the entire appeal for those representing the claimant in this case and those representing claimants in other cases. The suggestion that, irrespective of the circumstances, it can never be reasonable to attend such meetings. Because that is, we say, the point of principle is identified and determined by Master McCloud.
In the BCX case, and I appreciate timings were different, I mean, what caused the cost judge their real concern was that you had 86,000 on that aspect of it. And in your case, you've got 163,000. Any person with experience of these type of cases is going to be immensely concerned by those figures.
Well, actually, it's different again, my Lord, because in the BCX case, they were concerned with £86,000 worth of costs. That had not been recovered from the defendant. So there had been a significant tranche of cost beyond that had already been agreed and paid by the defendant. This was a shortfall that was being considered by Master Brown. So it's a slightly different point, and one can see why he might have been concerned as he was. But the point again goes down to essentially the detailed assessment or the consideration of specific circumstances that's required. The exercise that he carries out, or purports to carry out in that paragraph, is precisely the exercise that we say would be appropriate in this case. Yes, these costs can be reasonable. It can be reasonable to attend the MDT meetings or the rehab meetings. Given the particular issues at stake and their import to the claimant and the amount of costs and the proportionality and so on and so forth, was that attendance required? That's the point that we make. Moving on, my Lords, in the skeleton argument, we referred to the case of McGlynn and Waltham Contractors, a decision, I believe, of my Lord Justice Coulson.
A very, very long time ago.
Well, I can deal with it briefly, my Lord, because it...
I mean, that just said that costs of doing something under the pre-action protocol was recoverable.
Yes.
Which didn't strike me as being necessarily overly dramatic or groundbreaking.
Well, it's not. I wouldn't like to comment, my Lord, but in the circumstances of this case, it is relevant because the protocols, both the clinical negligence protocol and the personal injury pre-action protocols, do require consideration of the rehabilitation needs. And the point we make is a short one. If there is a requirement under the rules to engage in rehabilitative measures, and if the costs of complying with the protocols are recoverable, then self-evidently those steps done in relation to rehabilitation under the protocols should be recoverable. That's the point that we seek to extract from McGlynn. The case of Farrington, my Lords, is in the bundle, and I didn't take you to it at length. It was an application for an interim payment.
Which page is that?
It's page 100, please, the relevant part is page 100 of the authorities funding. Starts on page 98. I'm going to refer to page 100 and 101. It was an interim payment application, and the background was this. There had initially been a significant level of agreement between the parties as to case management and rehabilitation, and then it's clear that there was a dispute as to precisely what was involved. I don't seek to draw from this, my lords, any point of legal principle. What I seek to draw from this, and I'll take you to the paragraph in a moment, is an illustration of the way in which, in reality, solicitors have to be involved and are expected to be involved, to some extent, in the case management and control of the case management. And in paragraph 6, to which I'll refer, this is actually a letter from the defendant's solicitors. And they say there, the provision of case management and rehabilitation has been entered into in good faith by our insurer client. We must express that they are very close to pulling funding. We are struggling to see how the MDT meeting can be effective as it should be without Dr. Shotbolt or another psychiatrist taking the lead. Being present, there needs to be proper direction from somewhere to manage the effectiveness of this regime, etc. And the reason I highlight this, my lord, is that it is the routine practice of those in areas such as this to receive input from defendant insurers precisely such as this. Suggestions that maybe the rehabilitation is misguided, that it should be directed elsewhere. And the point I draw from that is simply this assertion that a solicitor cannot simply commission a case manager and then leave them to it. There has to be this ongoing level of oversight and sometimes direction. And it ties in with the Laughlin and Singh point. The judgment's not before your lordship because it's agreed, or rather the content of it's agreed. But in essence, in that case, the trial judge reduced past case management rehabilitation costs by 20%.
In which case?
Laughlin and Singh, my lord.
That's the one referred to by Mr. Roberts.
Yes, it is.
Are you saying we don't have that?
We don't, because it was suggested as being, I mean, we could certainly provide it, my lord. It was suggested as being unnecessary, the contents of it essentially being agreed. The principle rather being agreed. The principle being that if a judge on assessment determines that the case management has been misguided, in that case, there was an allegation or a suggestion that the sleep hygiene should have been assessed at a much earlier stage and treated, thereby allowing a lowering of care. But in that case, the judge accepted those criticisms and made a blanket reduction to the past case management and rehabilitation costs of 20%. Yes, the damages. So did it up? Oh, sorry, forgive me. Yes, my note event highlights that it was the assessment of damages in that case where there was a 20% reduction. Forgive me, I should have made that clear.
Well, that's completely different, isn't it?
Well, it's not.
It's making a reduction in damages because the case management had gone wrong.
Yes.
So that some of the damages weren't attributable to the breach.
Yes, that's exactly right, my lord. The point I make, though, is that this is why a claimant solicitor has to supervise or keep some oversight of case management. Because if they don't, at trial, they run the risk of losing 20%, say, of the past costs. Now, in our case, broad spend, as I say, to the end of last year, £900,000. If there was a suggestion, or if a suggestion might have arisen, that part of that was misguided, we are talking a huge amount of money that would have
been misguided for medical reasons.
Yes.
Not legal reasons.
Well, it can often be a combination of the two, my lord.
Well, it may be, but if case management had gone wrong because it had been misdiagnosed or somebody had thought that a particular element of rehabilitation was important and in fact it wasn't, I mean, that's basic assessment of damages.
Well, I can put the context, I can put the point, perhaps, my lord, into the context of the individual case, the specifics of this case. What happened in this case is that the Court of Protection had to be involved and there were litigated proceedings as to the discharge of the claimant. Now, if those instructing me had not been involved in the litigation and had simply left it to the case manager, then that discharge would not have been secured when it was. The claimant would have remained in the original rehabilitation unit, and alongside that we had this house rented and 24/7 care in place. We have to have that in place before we can discharge. So those carers had been recruited many months prior, and absent the involvement of those instructing me, that discharge would not have progressed as it did, because they were required to provide legal input, legal advice, and ultimately to recruit specialist court of protection lawyers to fight that issue in order to progress those matters. So we say, my lord, that it's not as straightforward as simply devolving control of the case management to the case manager and ensuring that they do a good job. Ultimately, we are responsible for employing the case manager. We choose the case manager. If they then fail to do a good job, as in Laughlin, the client will have a legitimate complaint or concern or beef, so to speak, about lack of oversight on the part of the instructed solicitors. Why did you not intervene? Why did you choose that case manager? Why am I having to meet £200,000 worth of costs from elsewhere in my claim? But that's the point about oversight, my lord. It is a matter, we say, of real significance to catastrophic injury claimant solicitors. The third point, moving on, my lords, relates to the involvement of the defendant in this case. And can I say from the outset that we are grateful to the defendants for the collaborative approach that they had taken in this case. They attended three.
That's one of the odd things about this case, that the defendant clearly has been collaborative, and you're now at the point where the case has just about settled. But you're arguing about a potential point of principle query arising out of one element of the costs.
Yes,
it seems a pity.
Well,
I put it no higher.
I agree, my lord. I agree that the point of principle is, however, an important one. It also has some slightly wider bearing, we say. It's not just to do with the £40,000 to £60,000 of estimated costs.
Well, we've been over that.
But no, I agree, my lord. Actually, there was very constructive input from the defendant solicitors throughout the proceedings. They acted entirely in accordance with the guide, the Serious Injury Guide and the Rehabilitation Code. They attended the relevant meetings at which funding was discussed and funding was agreed. And we say, in essence, that it would be extraordinary if our costs of attending those meetings were somehow held to be not of an incidental proceedings and therefore not recoverable, when not only was significant progress made of the issues in the case and of the case more generally, but also where that attendance by those solicitors was deemed appropriate on their side. And it is right to highlight, my lords, that the costs of attending those meetings did feature within the defendant's cost budget. It may be thought of as a small point, but those budgets have a statement of truth attached, specifically that these are costs thought of as being reasonable to claim, so to speak, my paraphrasing. And that being the case, we say the court can have regard to that. The defendant, very clearly, when preparing its own budget, wished to claim the cost of attending those meetings. We said it bears on the issue before yourselves. The only other point I wish to make about defendant practice more generally is to highlight that this is not an approach unique to the defendant in this case. As the court might expect, given the contents of the Serious Injury Guide and the Rehabilitation Code, although not ubiquitous, defendant solicitors very frequently do involve themselves in the rehabilitation in this way. And we included within the authorities bundle an article from the Journal of Personal Injury Law, not because it advances any legal principles in and of itself, but because it just demonstrates, we say, the sort of involvement that is frequently the case. And in that case, it's a case study essentially, Both sets of solicitors attended 10 different MDT meetings during the course of their collaborative approach. As I say, it doesn't establish any legal principle, but we do say it's important in demonstrating just how seriously both sides take the issue of rehabilitation and just how seriously they seek to pursue it, often on a collaborative basis. Those, my lords, were the points I wish to make in relation to our second ground, but can I perhaps just bullet point a number of propositions in seeking to draw those together? Forgive me for repeating points I've already made, but it may be convenient to bullet point them in this way. Firstly, we highlight the industry-wide recognition of the importance of rehabilitation at all stages. It helps with the recovery of the claimant, it lowers the damages payable by the defendant. Secondly, a particular choke point in personal injury claims can be the point at which a claimant is discharged either from one residential establishment to another or into the community. Managing that process is complex and fraught. It cannot simply be devolved to the case manager. It requires active involvement, in this case from both the claimant and the defendant's lawyers. Thirdly, in catastrophic injury claims, there is often a need to obtain very substantial funding, ideally by discussion, as here, or alternatively by the making of interim payment applications. Fourthly, we say that attendance at rehabilitation meetings by both sets of solicitors, where appropriate, inevitably provides a greater understanding of the case and of the claimant's difficulties. It allows the lawyers to tailor their inquiries, and it facilitates an open and collaborative approach, likely to reduce the costs overall and increase the prospects of negotiation. Fifthly, in catastrophic personal injury or clinical negligence claims, we say the claimant solicitor is the party responsible, at least initially, for commissioning rehabilitation, and initially and thereafter for exercising oversight and supervision in relation to it. Sixthly, in some cases, and we say this is just one, or just such a one, there will be a call on the claimant solicitors to provide legal advice. And lastly, seventhly, I make the point I've made many times already, that the concession having been made by the defendant as to what can reasonably constitute legal costs, it would be strange indeed if the manner in which those steps were taken were to be determinative of whether or not they were recovered. For all those reasons, we say that attendance on the part of the claimant solicitors at rehabilitation meetings can be progressive, not necessarily is, but can be progressive, and would on the facts of this case have been progressive. Any blanket finding that such costs are non-recoverable, we say fetters the court's discretion and cannot stand. The last point, my lord, in closing, relates to the alternative posited perhaps by Master McCloud, specifically that if these costs are needed, or rather if this work has to be done, then might it be recoverable as a head of damages rather than costs. But for reasons I've already given, we see that as less attractive. The difficulty with considering that conceptual issue today is that there is no such claim before you. And looking at such a point of principle in a vacuum, without regard to the sort of evidence that a trial judge might have, we say will be inappropriate and disadvantageous, perhaps to all parties who might be involved. But our primary case, for obvious reasons, is that the test was wrongly applied, and whichever test was or should have been applied, these costs were progressive and or met with the Gibson test. Unless my lords have any specific queries, those are my submissions.
I'm sorry, Mr. Mother, I think I've been a bit slow on the uptake. Can I make sure I've not misunderstood something? because you've explained quite properly that the case is settled subject to approval. Does that mean that there's in fact no dispute in this case?
No,
I know you don't agree with
no,
it.
it's a good point. We, before the settlement meeting, we specifically agreed that any negotiation would be without prejudice to this specific issue. And because it's an issue of costs, even though there is agreement between the parties, subject to court approval, that there be payment of the claimant's reasonable costs, the issue would remain live.
I see, because the costs haven't been assessed yet, so it will still
Indeed.
apply to that.
Indeed. Give me a moment, Noel. Thank you, Noel.
Thank you very much.
Thank you, my lords.
Yes, Mr. Stevens.
I think I can summarise the respondent's position quite briefly. It will be clear from our skeleton that this is our position. The starting point is that we don't consider that Master McCloud actually decided a point of principle, and that is clear from her judgment and her approach.
You don't consider that she decided...
The point of principle, that costs of attending MDT meetings are not recoverable per se. The costs of solicitors attending MDT meetings are recoverable per se, and that's clear from her judgment. We say that her use of the word progressive was a proper shorthand made by an experienced cost judge used to undertaking detailed assessments. We recognise, or we bear in mind, that the costs in issue here, or the costs in issue before the court at first instance, and therefore before this court, were the estimated costs of the cost budget, therefore not the incurred costs. And we say, as an adjunct to the points that have come before, that really what Master McCloud was doing was determining what was reasonable and proportionate, which is exactly what CPR 3 required her to do. And perhaps I pray and aid 2 points made by your lordships. One, I think, by my Lord Justice Coulson, who said that cost budgeting is a blunt instrument. And she was undertaking a blunt instrument assessment. And I'll come back to that in due course, if I may. And as illustrative of the point, and perhaps it's a short point, but the point made, or the illustrative point that she wasn't making a point of principle, is the point that my Lord Justice Dingemans made, which is that she accepted that there was some allowance to be made outside sums strictly for updating the schedule and considering the counter schedule, for ongoing liaison with the case manager. My lords, whilst we on this side of the court hear what the court has said about the I'll now turn to, if I may, to more detailed submissions, if I may. I want to deal very briefly with the further evidence. We hear very clearly what the court has said about the utility of this evidence. We support the suggestion that this evidence has no bearing. I don't need to remind the court that under CPR 5221, this hearing is not a rehearing, it's a review. And of the default point under CPR 5221(2), that no further evidence will be allowed unless the court orders otherwise. And I'm sure your lordships will be well aware of the Ladden-Marshall principles. We've included Ladden-Marshall. I don't propose to take the court to it, but the three questions are whether the evidence could have been obtained with reasonable diligence for use at the trial. Of course, there's no trial here. Whether it would have an important influence on the result, and whether it is apparently credible. That, of course, is a pre-CPR case, but you'll be aware of the authorities, and they're summarised at page 1803 of the White Book. I don't propose.
Are you asking us to make a ruling? Because that will involve us then looking to see whether the point was fairly and properly taken whether the master did decide a point of principle in circumstances where she might not have had all the kit, it becomes lengthy and potentially murky, which hence the suggestion of a shortcut.
My Lord, I don't require that this court makes a specific finding. What I would say is that I would echo this court's view that it adds very little. As to the murkiness, my Lord, I'd remind the court that the practice direction actually says explicitly that the court ought not to be provided with additional documents, only to be prepared in exceptional circumstances. If you'll note, that's paragraph 4 of practice direction D. It's at Authorities Bundle 16.
In relation to cost budgeting.
Related to cost budgeting?
No, but my practice was always, and it used to happen, if there was a point of principle that arose in cost budgeting, I made separate directions about that, and then sometimes you did have evidence.
Yes. Well,
the problem here is that, and there's no criticism of anybody that I'm making at the moment, but the point has emerged somewhat blushing into the spotlight. And as I say, if a point of principle had been identified, then the court would be anxious to hear from both sides and maybe have evidence from both sides. That wouldn't stop the court saying, we don't need all of this evidence and paragraphs X to Y are completely irrelevant, but you would give the parties the opportunity if such a point arose. This point arose at the hearing, and so I have some sympathy with the thing, well, we didn't realise this was emerging, or this was emerging in quite this way. So I think I agree that cost budgeting is a blunt instrument, and I agree that you don't tend to have further documents for that because there are usually quite enough to be going along with. But this is a slightly unusual circumstance. I don't criticise, but it is a slightly unusual circumstance.
Oh, yes.
And we have to frankly pick up the pieces of it all.
My Lord, we say that, as you'll have gathered from the short bullet points I said at the outset, we don't think this is a particularly unusual circumstance. We don't think there was a particular point of principle being taken. We say this was a matter of identification of what would be reasonable and proportionate going forward in the light of what information was both provided before the hearing, and I'll come back to that point in due course, and then provided during the course of the hearing.
Right. Well, and on the further evidence, is there anything else you want?
My Lord, no.
Okay.
My Lord, we start by dealing with that point of principle, and it's perhaps worth bearing in mind that this was a hearing before the Master in which the Master was only considering one head under the budget. The rest had already been agreed.
Yeah.
And I echo my learned friend in respect of ADR for budgeting. This was the first time I think that Master McCloud had ordered it. I'm not aware that it has been ordered in other cases. I've certainly asked for it to be ordered in other cases, and I think some judges have declined. But I won't go on and give further evidence. It certainly proved to be of great value in this case, subject, of course, to the caveat that we now find ourselves before your lordship.
Well, I mean, that can happen. You can, I mean, that we're not criticising you because there's an item that the parties didn't agree. You both seem to be agreed that ADR of these substantial costs was a good thing, and I imagine we'll reflect that.
Well, not only was it a good thing, it was a simple thing as well. It was the Master had in mind no more than the cost draftsmen speaking to each other and being required to try and agree where they could. So, in that sense, we do endorse it, and I would invite your lordships to endorse that.
Yeah.
But the upshot of that, I suppose, is that what the Master had before her was a claim for a very substantial amount of money for, now it appears, liaison, and I'm going to keep it in those brief terms, which was all to be put within, or to be considered only within one of the possible heads of the budget, the issues and statements of case phase. And that was relevant to how she approached her assessment, and it almost delineated her assessment. I've already made the point in my first bullet points that was this really a question of a point of principle? And I'd like to go back, if I may, to what the Master actually found. The judgment starts, my lords, at core bundle, page 43.
Yeah.
But in fact, the starting point, I think, is, well, she makes a comment as to this at the end of paragraph 9.
Well, paragraph 1. She says that it raises something of interest legally.
Yes.
This case determines one such specific issue,
Yes.
which she explains, and which she says are, in principle, costs which may be included in a budget.
Yes.
So, speaking for myself, I understand why you say this wasn't really a point of principle. The potential difficulty we have with that is that Master McCloud appeared to think it was, hence paragraph 1.
But then it may be that's right. But then if one goes on in particular to paragraph 14, my lord, on page 48,
Yeah.
the argument that simply attending on these individuals is an integral part of producing the schedule of loss and hence allowable for inclusion of bundled item under that head is weak in my judgment. I want to come back in due course to what Mr. Brighton, the cost draftsman, said in the hearing, because there was a change of position. She said, and this very much reflects what Master Brown had said in BCX, although of course that wasn't before her, information about case management or incurred expenses of such things as money management can be achieved by the occasional letter to the case management manager or relevant deputy, or from obtaining documents for later disclosure in the disclosure phase, and ultimately also in the case manager or deputy's witness statements, which may or may not be needed for the purposes of formal deputy expert. What she's recognising that there needs to be some liaison, and then there needs to be some evidence. She says those are qualitatively different things from attending meetings for input into a schedule of loss, as is claimed here on a very significant scale. Thus, nothing in this decision says that in principle, some phases in the budget cannot include engagement with case managers or deputies, such as for disclosure or witness statements and occasional letters. Past deputyship costs, one notes, are a matter of fact based on invoices, possibly assessed by the SCCO, and the cost of future cost of deputyship is a matter for deputyship expert. What she is saying, I interpret that as is, and we say it's the entire force of the judgment, is that what I'm looking at here as somebody undertaking a cost budgeting exercise is to work out firstly whether the costs are potentially recoverable. Can I put it in that most neutral of terms? I won't use progressive or use the Gibson test. And then she is saying as a second stage, as required by CPR3, are they reasonable and proportionate? So we say that it's clear. It may not be the most elegantly expressed, but it's clear that she's not making a finding of principle that solicitors can never attend case management meetings. So we say this is not a point of principle, and it's clear from what the master was.
Then what is it that's being leapfrogged to us?
Well, I agree respectfully.
That was the master's.
That was the master's decision. Yes.
So I go back to the point. She thought it was a point of principle.
Yes, but I don't think properly interpreted it is. And I don't think we made any submissions that this was a point of principle at the hearing. You'll no doubt have read the transcript already.
Well, that may be right, but you'll understand that's a bit academic for us.
No. Well, I appreciate that.
We have to address it, and put it this way: parts of the judgment could be read as identifying a point of principle, the point of principle that Mr. Barnes has addressed. Parts of the judgment might be said to be not. Is that fair?
That is fair, my lord. But
I mean, if qualitatively had read quantitatively, I would be more sympathetic to your submission. It is the qualitatively different I struggle with.
But we say that what the master is finding, what the argument was before her, and what the matter she was considering, the test she was using, all points in the direction of she was undertaking the blunt instrument of cost management on the limited information in front of her, as would be expected under Part 3. And it's plain from paragraph 14 that she is assessing the reasonableness in the same way as she would any other part of reasonableness. And indeed, that's why, if it is right that this is liaison amounting to attending case management meetings, and I'm far from clear that it is that, because we'll come back to the transcript in a moment, but she is allowing some liaison, and the question of whether it's case management meetings or not is neither here nor there.
Liaison with?
Between the solicitor and the case management team, for example, the solicitor and the deputies.
So when you say liaison, that's cost of liaison, which is your word,
yes.
Cost of liaison between claimant solicitor and case management team.
Yes,
and deputies.
And deputies.
And deputies.
Yes. And one can look at that, I'll come back to this a bit later on, but one can look at that on a wider or narrower basis. But the narrow basis is there plainly needs to be some liaison, and I use a deliberately obscure word, because at some point there needs to be a schedule updated. There was, of course, already a schedule in this case, amounting to some, I think, £27 million. It was a very detailed schedule. That would, of course, need to be updated, and it would need to be, and there would need to be consideration of the counter schedule in due course. But put aside consideration of the counter schedule, one would need the data to go into the updated schedule. And the other aspect is that the solicitor would need to be aware of the ongoing status generally, because, for example, in terms of funding, if there was going to need to be an interim payment application, the solicitor would need to know what funding was left, and when one might need to approach the defendant and when one might need to make an application to make sure the funding didn't run out. That's the sort of liaison I'm talking about. But the assessment of the extent of that liaison is I suppose it is a quantitative, it might also be described as qualitative, but that is what the master was doing. And with respect, because she allowed that, Lord Justice Dingemans pointed out, she plainly had in mind that there was going to be some ongoing liaison. We don't read the judgment as being there is a blanket ban on attendance at case management meetings. Rather, she was making the point much more akin to that made by Master Brown in BCX, albeit on different facts, that we see it as rather difficult to see what a solicitor would have to offer in a case management meeting, a clinical meeting. So in that sense, we say this isn't a point of principle that solicitors can't attend MDT meetings. What she is saying is that the costs I'm assessing have to be progressive. My Lord, the next point we make, and I'll make it very quickly, is that it relates back to the review point, and of course, you've already been referred to the authorities in terms of discretion, and you'll be well aware of the authorities in terms of discretion, and the court not interfering in discretion. And we say the outcome in this case is very much an exercise of a case management decision, an exercise of very wide discretion.
Well, that's the other side of the coin of the point of principle. It looks as if we may have to decide whether or not she decided a point of principle. If she didn't, then you say this is cost budgeting from soup to nuts and not a matter for the Court of Appeal.
Yes, we make the point in that this is effectively a case management decision. We should bring to the Court's attention there was a decision of Mr. Justice Kerr about 10 days ago in William and the Ministry of Justice. I can provide a copy. In which it was suggested that cost management decisions aren't in fact case management decisions, but it's on a different point, and he specifically declined to come to a view on it.
The cost budgeting decisions weren't case management decisions.
It was an element of cost budgeting, and whether or not that was a case management decision per se.
On the face of it, having exchanged glances with Lord Justice Birss, I think. Since he's the Deputy Head of Civil Justice and the fount of all knowledge on these matters, it may not be correct.
Well,
we may not reach the same view. But anyway, but it is the flip side.
It is
a point of principle, or it's a case management decision.
Yes.
I mean, it can't be anything else.
And it's very much akin to a case management decision if it's not purely a case management decision. Of course, I hear precisely what this court's view on that is. It's the sort of thing that masters do every day, and this is a very experienced master, and I should say a cost judge.
Yeah.
And we pray that in aid in saying that when she refers to the shorthand of non-progressive, she has very much in mind the discretion that she had. But what I want to touch very briefly, if I may, just by way of background, the court may not find it that helpful, but I'm just by way of background, the sort of figures that we are looking at. We deal in paragraph 13 of our skeleton what was sought. So incurred in this phase already had been 544 hours.
Hang on, wait,
My apologies, it's page 30.
It's your skeleton, it's page...
Page 30, core bundle 30, page 13.
Yeah.
$544 hours incurred, and of course we're not interested in the incurred costs because those will be dealt with by detailed assessment. That's the equivalent of just 72 and a half odd days, or 14 and a half weeks at 7.5 hour days. The estimated was 258 hours, which at 7.5 hours a day is 34.4 days, or nearly 7 complete working weeks. And just for the total was 107 working days on the issue statement of case phase, or 21, or nearly 21 and a half working weeks only on this phase. And although it's in the bundle, I'm not going to take you to it. For your references, at supplemental bundle, page 55. I wanted to just deal with the disclosure phase. So incurred in the disclosure phase was 302 hours. Sorry, I should pause. The reason I refer to disclosure is because when I was talking about liaison in its loosest form before, some of the information is going to come from direct contact and some will come from the documents. Solicitor reads the documents to find out what's going on. That presumably goes in the disclosure phase.
So which page?
So the bundle. So it's at page. The budget is at supplementary bundle, page 55.
Can you just repeat what you said you thought the disclosure phase was?
The disclosure phase figures.
No, you said which you thought, and you told us what it was, but I didn't make a note of what you said.
So the disclosure. When I was talking about liaison, when I was dealing with liaison before. So the claimant solicitor finding information as to what's going on as to the claimant's status.
Yeah.
We accept that there will need to be some active liaison, as it were, so speaking to the case manager and the deputy. But there will also be some passive liaison, as it were. Each of the deputy will create a file, the case manager and every therapist will create a file. Those will need to be disclosed and they need to be read by the solicitor. That forms part of the disclosure phase. It's part of the information that is available to the solicitor. I thought it would be useful if the court also had in mind, which the master no doubt did, that the front sheet of the budget is at 55. The disclosure phase is at page 57. So just to put the figures there on the right in the right-hand columns in context. The incurred hours were 302.2 hours in total. A total of just over 40 days, or just over.
Which figure are we looking at?
So it's the 89,805, my lord.
Page
57, my lord.
Page 57.
Yes. So if one breaks, it's the maths of breaking 89,805. Break its component parts down by the hourly rates to the far left.
Yeah.
One gets to a incurred disclosure of 302 and a little bit hours, which was just over 40 days at 7.5 hours a day, or eight and a little bit, if I can put it that way, working weeks. The hours going forward are rather more simple to work out because they're there for us. It's 50 hours split between grade A and grade D. And so the total was 9.4 working weeks of time on considering the disclosure. Some of which will be, well, all of the disclosure in a case like this is going to come from the claimant. Most of it is going to be medical records, treating records, therapy records, deputyship records, and the like. And so the master would have had in mind, in the back of her mind, when she was considering this, well, what are the sources of information available to the claimant's solicitor for the purposes of that passive and active liaison? And she will have had in mind the fact that there was a very substantial amount of time. I don't mean that as a criticism, I just mean it as a figure. A very substantial amount of time based for disclosure. My learned friend says in his skeleton that we risk looking at this in a vacuum. Well, we have two answers to that. One is, well, three answers. One is it's not a vacuum. Two is it's the standard vacuum that would be in front of the court. But three, what the claimant seeks to do is to almost ask this court to turn a blind eye to what other sources of information or other manners by which the claimant solicitors might obtain information, other than those from attending MDT meetings. So we make a further point that it's hardly surprising in those circumstances that the master raised a concern as to the levels of the costs. Because in that there are 2 points. One, the costs were, and I'll put it as neutrally as possible, very high. Both those before her and those which she couldn't deal with, the incurred costs, but also in terms of how they were explained. My Lords, can I turn next to the complaint that the defendant, respondent, had failed to foreshadow a point of principle? Mm-hmm. Well, our starting point on that is that we're dubious there is a genuine principle here. Can I go back, please, to you may still have it open, the budget. Mm-hmm. This time we go backwards a page to page 56. This is the phase that we're looking at. I'm not interested in the numbers now. We've looked at that. I'm more interested in the assumptions at the bottom of the page, my lords.
Yeah.
It is brief, extremely brief. Again, I don't necessarily criticise that because the practice direction, it's in the authorities bundle, expects the assumptions to be brief. But it hardly sets out quite how these figures are made out. Preparing an updated schedule of loss, reviewing and advising upon account scheduling conference. Working with the case manager and deputies throughout. There's no breakdown given between the two. There's no suggestion of how that working with the case manager and deputies is to be broken down or is to be assessed. The defendant's submissions could only respond to what was in front of them. And if I can ask you, please, to go to supplemental bundle page 85. This was the respondent's submissions, responding to now only, there were a set of earlier submissions. This only now responded to that particular set of assumptions and that phase of the budget. And you'll see over the page at page 86 is the commentary, and it's rather more detailed than is often provided for cost budgeting. Often these things are just dealt with on the fly, as it were. And I know I've been accused of already putting in one glibism. I'll introduce a second. So this is rather more detailed than ordinarily be provided, but the response is given in detail. It raises the point, for example, at paragraph C as to recoverability of costs caused by the family, point that's been flagged by this court. But then at paragraph D on page 87, it deals precisely with the issue we're dealing with, insofar as it responds to what was available to be responded to. The defendant respectfully submits that the only work of any meaningful substance remaining to be undertaken in relation to this phase, bearing in mind the guidance of CPR PD 3D, will be to finalise the schedule of loss and to give consideration to the defendant's counter-schedule. It's accepted that some additional work will be required in order to liaise with counsel, the case manager and deputy. So that was always conceded, as detailed within the assumption of the budget. However, the time estimated goes significantly beyond what would be reasonable and proportionate. So we say it is unfair to criticise the defendant for failing to foreshadow a point of principle when it had already set out a detailed response to precisely what had been put in the assumptions. We don't say that there necessarily should have been more in the assumptions because the CPR doesn't request that. Of course, if you want to make these points, if you want to get the point home, perhaps they should have done. But equally, it ill sits within the claimant's mouth to say, well, you then didn't set out what the position was going to be. And we say that in any event, it was the claimant knew exactly what the position was in the hearing. Can I ask you to turn, please, to supplemental bundle page 99?
Yeah.
So remembering that in this hearing, the claimant was represented not only by my learned friend, an experienced silk, but also by a cost draftsman. At the bottom of the page, you'll see just above G, Mr. Barnes, yes, 99, supplemental 99. Yes, you will see essentially that the only item in dispute is the issue of statement of case values. Yes, what does this relate to? Updated schedules, says the master. Mr. Barnes, no, it's not just the updated schedule, it's the updated schedule plus all the rehabilitation and case management going forward.
Yeah.
Then the master then turns to Mr. Brighton over the page.
Can I just ask a question for my note? At that stage, at the stage of the argument, had the fourth stage of the rehabilitation commenced, i.e. the claimant had moved out?
Yes.
Yeah.
Yes. And that's relevant, my lord, to the point that we are
No, I understand.
Estimated costs. Yes. Mr. Brighton is the cost draftsman. Over the page,
Sorry, which page are you on now?
We're now on page 100, just below A, my lord. Yeah. We'll see that I'll ask you to read down to D.
Yeah, it's A to D is the...
Yes.
Yeah.
This is the first time it's being set out. And we say that Mr. Brighton knew exactly what was being sought. He starts by saying it's a great deal of work relating to therapies and rehabilitation. The issue seems to be whether the cost of that work can go into the issue phase or not. The defendant's submissions, which you may have read, focus very narrowly on the core work of the issue phase, the schedule loss, the counter schedule. They seem to ignore entirely all of the extra work that is needed that the defendant is himself involved in funding. So I think were the defendant to have accepted that the work is needed and it should go into the issue phase, we probably would have agreed that one too. So, again, not the most elegant of submissions, and it's always slightly embarrassing to read back one submissions on a transcript, but it's perfectly clear. We say that they knew exactly what was going on and what was in issue. In fact, Mr. Brighton changes position during the course.
I mean, I've read that paragraph in advance of the hearing. I read that as indicating that the point was whether this came within this part of the budget. The issue solely seems to be whether the cost of that work can go into the issue phase or not.
Well, I think I read it as it being rather wider, and
But we have to remember that your submissions, as you've shown us, were saying that these are not reasonable or proportionate.
Yes, but that's the. So, and we made, I accept that we made 2 points during the course of the hearing. One is, does it fit in this phase? And two, even if it does, these costs are far, far too high.
Yes. What is not at this stage live in either your submissions or the response from the claimant is the point in paragraph 1 of Master McCloud's judgment.
Well, indeed. But that is because I think, I don't wish to accuse cloudy thinking, but it's precisely what I intend to do. I think the claimant's cost draftsman was rather unsure of what their position was, because when one sees at 103 at F, what he then says is, well, he's asked by the master, what help can you give me in terms of any precedent there might be for including case management cost in this phase rather than part of the damages? And he shifts position rather, and he says, these costs, are fundamentally intrinsic to the schedule of loss. There's no difference between sitting down with the claimants and working out what their travel expenses are going to be, to sitting down with the case manager and working out what the therapies are going to be. Well, that's plainly wrong, but I'm not going to deal with that for these purposes. It all comes into the schedule of loss one way or another. It's all working out what needs to be done. So in fact, the claimant then shifts position to be saying, well, in fact, these costs only fit within that phase because they are effectively the costs of drafting the schedule.
Why did you say that what he said was that, I mean, sometimes you have to sit down with the claimant and say, well, you had extra costs of going to and from a hospital, what were they and how often? And sometimes you have to sit down with the therapies manager and say, how much have you incurred in terms of costs? What's wrong with that point?
Well, if he had said to work out what the costings were going to be.
Well, that's what I either read or misread that.
Well, I read it as being slightly wider, because it's working out what the therapies are going to be, i.e. it's a collaborative process of working out what the treatment is going to be, which rather fits with how he had suggested, what he'd said at paragraph 100 page 100 at A, when he said a good deal of work in that phase related to the claimant's therapies, his rehabilitation, the ongoing structure of a case manager and his deputy.
Well, I mean, obviously in a schedule of future loss and damage, you're going to have to say, and physiotherapy 5 times a week. So that is working out what the therapies are going to be, not in an impermissible way. That's just actually working out what are the therapies and how much they're going to cost.
Well, the court needs to tread quite carefully there, of course, because a point that I'll make later on, but I might as well make it now, is that such costs are likely to be dealt with by the experts. The experts will say, this is what the reasonable costs are going to be going forward, and those are what are translated from the experts' reports into the schedule.
Yes, but by this stage, you may well have had the defendant's experts on therapy who says, well, actually, the idea that he should have 30 hours a week is hopeless. It should only be 10.
Yes.
You might be discussing that.
Yes.
I mean, that's all I'd read that.
It may be that I'm reading too much into that, but I see your lordship's point. But then, just finalising this point, if one then turns over to 109. The exchange starts just above C. Master McCloud asks, have you got figures in terms of how much you've included in the schedule, how much have you included for the case manager, and how much have you included in it for deputies? Have we got a bit of a breakdown? I do in terms of the schedule of loss, the counter schedule and work with counsel. The defendant obviously agrees that in principle, and for that they offer, I think it's 60 hours, is it? Mr. Barnes says yes. We claim that at 96. There's then a correction to that. At E, he says actually 48 hours. It's 48 hours for which we sought £12,900, plus the £4,000 council fee. That was the disbursement I was referring to that was agreed. So the work comes out about 3 hours per week between the deputy for health and welfare, the deputy for property and affairs, and the case manager. So on average, about an hour a week for each, which is nothing outside the general updates that are in principle agreed to be recovered. So, in essence, what he's now saying is that those extra average of 3 hours a week are the costs of liaison.
And then at the foot of that page, you say it's a question of recoverability per se.
Yes, and perhaps
might be thought of as a point of principle.
Well, yes. But if one looks at the thrust of my submissions, what I was saying is, are they progressive? Are they actually? This court should be looking at is what's the reasonable amount going forward? What I was saying, again, perhaps inelegantly, was that you simply can't. 3 hours per week just for attending, because what it seemed to be suggesting was for attending all case management decisions cannot be right. And I'll pause in a moment because I see the time. Drawing the point to an end, what we say is, going back to Lord Justice Dingemans' point, is that the Master realistically understood that and allowed an amount in that regard. My Lords, is that an appropriate moment?
I think my description of this blushing into the spotlight is more and more confirmed by these passages, but there it is. Yes, all right, well, we'll come back at 2. How much longer do you think?
I would say about half an hour, 40 minutes at most, Master.
Yeah,
My Lord.
Fine, okay. 2 o'clock.